Your attendance shall be heard. You can be seated. Welcome to the Appellate Division, First Department. We have over 6 hours of argument requested today, and we have read all of the briefs and records and are familiar with the cases. I therefore ask you to only request the time that you actually need for your arguments. The first case is People versus Roy Daniels. Respondent? Okay, I'm going to make it 6, 1, and 6. Law Office of J. Bacher versus Safir. Okay, that case is submitted. Nordica is submitted. Olivo Feliz versus County of Westchester.
Your Honor, appellant may have 6 minutes for argument and 2 for reply.
Okay. I'm sorry. 6. Okay, 6, 2, and 6. GCP Capital versus Greco. Respondent?
Good afternoon, Judge. 5 minutes for the respondent.
I'm going to give you 5 and 2, and you'll have 5. Williams versus 100 Church Fee. Okay.
Respondent requests 4 minutes.
Okay, 5, 1, and 4. Hernandez versus Con Edison.
Good afternoon, Your Honor. Appellant requests 5 and 1.
Respondent?
Yes, 5 minutes.
5, 1, and 5. People versus Allen is submitted. Board of Managers versus 336 East 54th. Respondent? I'm going to make it 6 and 1 and 6. Comptroller of City of New York versus Bank of New York Mellon.
For appellant, Your Honor, we request
6 and 3.
6 and 3.
Okay, respondent? Is respondent not here? Okay, do you want to submit or do you want some time to,
I'd be happy to argue in case the court has any questions.
you know what, I'll just put you down for 3 minutes. Sajas versus Mendelo. Respondent? Okay, 6, 3, and 7. People versus Muniz. That is submitted. Kovaci versus Brevet is submitted. Chrysler versus BU Realty Corp. Respondent? Okay, 5, 1, and 5. People versus Albandos. Okay, that's submitted. Morley versus Blackstone Group. I'm sorry, 7 and what? Respondent? Okay, I'll give you 5 and 2, and I'll give respondent 5. Katsi Corins versus Moskovitz. Okay, 6, 2, and 6. Payne versus NHA Community, the appeal is adjourned. People versus Perino is submitted. And New Global versus Lynn is submitted. So the first case will be People versus Daniels.
Yes, good afternoon, Your Honor. May it please the court, Whitney Elliott of the Legal Aid Society for Appellant Roy Daniels. Two settled search incident to arrest principles resolve the suppression issue in this case. First, as this court held in Morales and as the Court of Appeals recognized in Mabry, exigency under Gokia and Jimenez is assessed at the time of the search, not at the time of the arrest.
Counselor, before we get to that issue, shouldn't we be discussing waiver?
So, 3 points about the appeal waiver. First, the court expressly told Mr. Daniels that the waiver only covered, quote, certain statutory rights. That description of the scope of the waiver was incorrect on its own terms, and especially misleading in this case when the only issue...
I'm sorry to interrupt, but wasn't there a written waiver signed in this case as well?
There was, but the Court of Appeals has confirmed in Thomas, for example, that a written waiver can only have curative effects if the court confirms on the record that the defendant has understood the content of the written waiver. There was no questioning of him whether he understood the content. All there was counsel's statement, I'll ask him or I'll have him to sign it. The court never...
But there was nothing about, it was discussed with his attorney or anything like that?
There was not, Your Honor. All about the written waiver was defense counsel's statement, I'll ask him to sign it or I'll have him to sign it. There was no addressing him. Have you discussed it with your counsel? And certainly not, do you understand the written waiver? There was no inquiry at all about whether he understood the content of it or whether he'd even read it, Your Honor.
Counsel, getting to the substance of the case, why isn't this case more like Velez than Jenkins, in that he was still in the area where he could grab the gun, unlike Jenkins, where they were off in another room, handcuffed, secured, and nowhere near the box when it was searched? Well,
I guess 2 points. In terms of Velez, Your Honor, it doesn't really describe what exactly the facts were. It just says, I think, although he was handcuffed, it was still within his grabbable area. But I think our fundamental inquiry, Your Honor, and it's what Jenkins controls here, because Jenkins confirms that the exigency inquiry is a fact-based functional analysis focusing on realistic probabilities, not a presumption-based analysis focusing...
I know, and you look at it, assuming you look at it at the time of the search itself, Jenkins, it was a very black and white case on the facts, in that they were handcuffed, they were off in another room, there was no question they were secured, there was no question that they couldn't get to whatever was in that box. Unlike this case, where he was standing right there, he was not off in another place, and it was within his grabbable area.
So 2 points about that. One, just a procedural point. I would just say the other side doesn't even argue that at the time of the search there was exigency here. They've rested their entire point on the applicability of the time of the arrest rule, so there's no even argument, even from the other side, that at the time of the search there was exigency or that it was within his grabbable area. But second, and I think more substantively to answer your question, Your Honor, this is a black and white case. At the time of the search, before Officer Lopez searched the bag, the backpack was on the ground. My client was standing in handcuffs with a separate officer holding him. Up until that entire time, he had cooperated. He had admitted that he had marijuana on his person. He complied with the request for his ID. There was never any testimony that they feared him or that he did anything to resist. This is a black and white case that in those circumstances...
But counsel, is that really accurate? Wasn't your client within, I understand he was handcuffed, but wasn't he within the grabbable area, approximately close to the backpack?
No, because again, the grabbable area inquiry is focused. If he was not handcuffed at the time, perhaps the record might suggest that, but he was handcuffed, and we have to focus on the facts.
But wasn't that also true in Velez, that the defendant was handcuffed?
Well, it's not clear because the facts aren't fully really explained in Velez really at all.
I think it states, though, that he was handcuffed.
It does, but it also says it was in with his grabbable area. So we're not asking for a per se rule that when you're handcuffed, you're automatically outside the grabbable area.
But in this case, he was in the grabbable area, no?
No, because he was again, Velez doesn't explain whether...
But you say on one hand you're not asking for a per se rule, but you're arguing a per se rule.
We are not arguing for a per se rule, Your Honor. Here there was, not only was he in handcuffs, but he was being held by the non-searching officer. And up until the time of the search, he had complied in
But
all
your
every
argument,
respect.
but counsel, your argument sounds like, to me, that you're linking the fact that he's handcuffed, right? Because, I mean, it just makes sense, right? If you're handcuffed, you're immobile. I mean, it sounds like that's where you're headed for. That's what you're asking us to say. Now that you're handcuffed, it doesn't matter if it's in the grabbable area, there's no exigent circumstances. I'm not
Your
sure
Honor,
the cases stand for that proposition.
Well, Your Honor, a couple of things. I would recognize that, although we're not asking for a per se rule, but it is true that in the large majority of cases, when someone is handcuffed,
And not asking for a per se rule, but it sounds like it's a per se rule that you want to get.
well, it is true that in the large majority of cases, when someone is handcuffed, that any container will not be in the grabbable area. So a couple quick points about it. I would just urge the point that, footnote 4 in Gantt, they make the same point that, yeah, it's true, when an arrestee is handcuffed and removed from the area, that in just about all cases, officers won't be able to search the car. It's really the same analysis here when someone is handcuffed, and especially when they're restrained by another officer and they've complied in every way. That container is not in their grabbable area. So we're not suggesting that perhaps there are circumstances when there's one arresting officer and an arrestee has resisted arrest in some way, that it might be in the grabbable area. That's not the
Okay,
facts
you'll
here.
have time for rebuttal. Thank you very much.
Good afternoon, Your Honors. Carl Dubel for the people. I just quickly note that the defendant did waive his right to appeal in this case. If there's no questions on the waiver.
Well, I have a question. What about your adversary's arguments with respect to the written waiver, that there was no inquiry about it, et cetera, et cetera?
The court asked defendant if he understood the ramifications of the waiver, and defense counsel said that she explained the waiver to him and that she was having him sign the waiver in open court. So based on those facts, we believe that it's clear that he did understand the ramifications of that written waiver. As to the suppression issue, this was a valid search to arrest because, as Your Honors noted, the backpack was in the defendant's grabbable area. The search took place right at his feet in the apartment lobby.
I think his argument, unless I'm hearing wrong, it's sort of linked to the fact that he's handcuffed. Everything, irrespective if it's in the grabbable area, the fact that he's handcuffed takes it away from the exit. I mean, I think that's what he's arguing, and he's trying to get that kind of, the court to, go further with this, right? I mean, that's what he's saying, right? It's because you're handcuffed, you're done. There's no exigent circumstance. I'm not so sure the law is there.
Yeah, the law is very clear that whether a defendant is handcuffed or not during a search is not a per se rule, or whether it's a dispositive factor. This court in People v. Harris, for example, is a very similar search, and the court endorsed the argument that just because the defendant was handcuffed, because the search was happening right next to him, he could still disrupt the search in some way, either by kicking the bag or trying to resist arrest.
Which is why I think the decisions seem to always focus on the grabbable area, irrespective of the restraints that the defendant is under. We're talking about grabbable area because there's so many things that can happen when something is going on, right?
Yes, I agree, Your Honor. And obviously, if the bag is outside of a defendant's grabbable area,
If it's in another room or secure, yeah, I mean, you're not in the grabbable area.
which is what happened in the Court of Appeals case, People v. Jenkins. The police, there was multiple police officers inside the house. They had complete control of it. The defendants were handcuffed in another room, and the search took place in a different room, which is just not the case.
The focus is always on grabbable area, not the restraints.
I'm sorry, I didn't.
The focus is always on the grabbable area and less on the restraints.
Yes, I agree, because if it's in the grabbable area, the chances of him disrupting the search are high, especially because here the police knew for a fact that there was a gun in the bag. If there's no further questions, I just ask that you affirm.
So, Your Honor, I think of 2 quick points in rebuttal, Your Honor. Just in terms of the grabbable area inquiry, I just want to bring it back to what Gantt says search incidents to arrest further. It's to protect officer safety and prevent the destruction
but that's the
of...
whole thing. That's why the concept of the grabbable area got developed, because with restraints of an individual, I mean, a lot can happen in terms of restraining individuals. So that's why the court comes down with the theory, or at least the concept of a grabbable area. That's a little bit more workable and then trying to figure out and piecemeal out and try to separate the proper restraints. Were they sufficient restraints? Were there less restraints? I mean, then you get into so many gray areas. When you talk about grabbable area, if it's right there, it's simple. We got it. It's a physical, you can look at it objectively. With restraints, there's too many things going on.
Well, I think with respect, Your Honor, I think the grabbable area factors in the restraints. And again, just the purposes of the doctrine are to promote officer safety and prevent the destruction of evidence.
But in this case, there was a CI, correct, who said there was a gun in the backpack. So there were exigent circumstances on top of that. So wasn't the officer's safety at issue?
At the time of the arrest, perhaps, Your Honor, but at the time of the search, and that's the time that matters. When my client is being handcuffed, restrained by one officer, there's no realistic possibility that he can harm the officer or destroy any evidence in that backpack.
Okay.
And that's what matters. And
Thank you very much. Felix? Felix versus County of Westchester?
May it please the court. I'm Brett Hupart, counsel for appellant Jose Olivo Feliz. What the lower court did here was reversible error. Before one whit of discovery was ever done, was ever exchanged, both sets of defendants made motions for summary judgment. The Transit Authority defendants also made a motion to dismiss.
Well, let me ask you a question. Is there any dispute that these defendants who were dismissed did not have the responsibility to maintain these signs?
Absolutely, Your Honor. In fact, one set
What's the support? Isn't there clear case law that it's not their responsibility, that it's the city's responsibility?
No, there's no clear case law. There's nothing in case or in fact. And again, and one of the sets of defendants, the TA, just to be reminded, doesn't even annex proof. The case law they cite is not relevant to this. There's nowhere in the case law, whether many of the cases they cited from another department, or in fact, because they didn't submit any proof, that says, establishes that the city is responsible for these schedule box signs. The cases cited were in large part trip and fall cases.
GAL, doesn't GAL stand for that proposition?
GAL doesn't. I believe GAL is...
GAL we held, in
Yeah.
GAL, the second department held, even if it was related to a bus stop sign, right? And doesn't the court go on to say that's the responsibility of the city?
Well, GAL, again, is the second department, and that deals with a protrusion from a sidewalk. As I was about to say, many of these cases that are cited and relied upon are sidewalk liability cases, including protrusions. They're not dealing with the schedule box. They're dealing with a remnant of a pole.
But the issue is broader. The issue is who has the duty to maintain, right? That's the issue, and it seems to me that this case applies. But in any event, are there other theories that you have that go outside duty to maintain?
Well, absolutely. Well, I have, my one very prominent idea here is, aside from the Transit Authority not citing to the relevant law about the schedule box or submitting proof, the County of Westchester defendants, they actually admit in their affidavit that they have control over the instrumentality that causes this injury, this incident. They impliedly admit it by detailing everything they do to this schedule box, and then saying they don't otherwise have control. And control engenders a duty. So they had a duty.
Why does control engender a duty?
Because it shows that they had this relationship to a sign. I cite two cases that establish that, that control. It's the Reed case and the Gibbs case. The Reed case, this court stated proof, a motion for summary judgment was denied because the defendant's proof was insufficient that it lacked control. And over here, the proof doesn't even show that it's not even insufficient. They actually admit control. And the Gibbs case, it says liability may be predicated on control.
What
And they
about the line
impliedly
of
admit it.
cases that say it's the city that's responsible for bus stops? Why wouldn't this just be part of the bus stop that a city is responsible for?
Well, it does say that the city is responsible, and again, those are sidewalk liability cases or protrusions from the sidewalk. But that doesn't interdict a finding of liability against other parties. There could be more than one tortfeasor. There could be more than one proximate cause. Over here, especially in the fact that the Westchester defendants are admitting control.
Well, Counselor, aren't you actually arguing that it's a cause and create? Are you making that argument as well?
Your Honor, I didn't hear
Are
that.
you making the argument that the defendant's employees caused or created the alleged defect?
Well, Your Honor, that would be a part of it, that considering that they're the ones that have this special tool to open the sign, to unlock the sign box and open it, it is a matter of control and whether they created it. And at this point, there's been no discovery. They haven't produced anybody. The one item that is produced by anybody is an affidavit where control is admitted, where all the things they do for that box, all the work that they do is admitted. And yet the lower court, before discovery, before anything, even with this admission, dismisses the case, and that was error. There's no other questions?
What about transit? I mean, transit has not admitted to anything.
Your Honor, I missed.
You haven't argued anything with respect to transit.
Yes, transit hasn't admitted it. That's the county of Westchester that's admitted it. Transit is relying upon the string of cases that deal with sidewalk liability or otherwise trip and falls, and they also rely upon a case saying they don't have to submit proof, but that's wrong. That case, it's Keegan, doesn't stand for that. In Keegan, one item of proof wasn't annexed to a motion. It was condominium documents, but this court was able to find otherwise in the record proof regarding the relationship that would otherwise be in the condominium documents. They just didn't submit any proof. They're required to, statutorily, 3212, and it's established in the case law of the Court of Appeals. You have to submit proof. They didn't submit proof. They're just relying upon cases. It doesn't establish their right either under 3211 or 3212.
Thank you very much. You have a chance
Thank
to
you.
rebuttal.
Your Honors, may it please the Court, Catherine Woodhouse McGerald from Keene and Bernheimer for the County of Westchester, the Westchester County Department of Transportation, and Beeline.
Counsel, why shouldn't the plaintiff get discovery on the issue of the creating the condition based on the admission that they were using these boxes, they were taking things in and out of it with a special tool? Don't they at least deserve to have some discovery on the issue of whether Westchester may have caused the condition?
Well, there was no admission. There was just a statement that they intermittently, not on any schedule,
I'm not saying
changed out.
admission, I'm saying they stated it, and doesn't that create a basis, that statement, for at least some discovery on the issue of creation of the...
No, the lower court held that the plaintiff is not simply entitled to discovery to try to find an issue of fact. So the plaintiff has not met their burden.
Well, but wait a minute. The burden in the first instance is upon you as the
Yes.
movement. How did you address, as my colleague posed to you, the issue of cause and create? In your moving papers, how did you address that?
Sure. The plaintiff wants us, well, the Westchester defendants do not owe any duty or did not breach any duty to this plaintiff. They use a tool here and there just to take it out. And
Counselor, in your papers, do you address the issue of cause or create? I understand what you're saying, that there's no liability because you don't have a duty to maintain. But with respect to the discrete issue we're asking you about, was that addressed, and did you make a prima facie on that issue?
can you rephrase it? Can you ask the question again, please?
Did you, in your papers, address, in your moving papers, the issue of whether or not your employees caused or created the defect?
There's nothing to indicate that our employees caused the issue.
Counsel, it's
And we addressed
alleged-
the
it's
issue-
alleged in the complaint. Let's take that as a start. The complaint does allege a cause and create allegation. Once the complaint alleges it, doesn't that create a duty on your part to at least make a prima facie showing, as my esteemed colleague just stated, to show that you did not cause or create it? And did you do that since it was raised in the complaint?
And the prima facie showing would be through the small amount that is done by the County of Westchester on those signs and boxes, and the fact that the New
I'll
York
make
City
it very
Charter-
simple for you, counsel. As my esteemed colleagues have been asking you, do you have an affidavit from the person who did the last opening of that box?
Do we have an affidavit from that person?
Who opened the box the last time before the injury happened, before the accident happened?
No.
Because to me, that would be, he or she's the last person that operated it. To me, it would be like, I went, I opened it up, I closed it, I left it, I checked it, everything was perfect. That would be your I would think that that would satisfy my colleagues here as the prima facie that you didn't cause or create.
But to require that in every case would be...
It's your burden for summary judgment, so you
Yes.
need to have that as a prima facie. Then he would have to come back and raise a factual issue.
That's not part of the prima facie case. Part of the prima facie case would be to show that we don't owe the duty of care.
You don't owe a duty of care, but if you cause and create it, then you do owe a duty of care. At least that's my understanding. You don't have a duty of care, right? But if you cause and create a situation, then it becomes a different analysis.
But there's nothing to indicate that we did cause or create.
That's why I'm asking, do you have an affidavit from the individual who opened the box last?
We don't, either from the City of New York or from the County of Westchester.
Okay, fine, that's my answer. Got it.
To address what respondents' arguments, it is an admission in their affidavit. It says the Westchester County Department of Transportation does not, going down a little bit, otherwise control the aforementioned pole or ride guide.
You can move off the control issue. I think, you know, we're looking at cause and create now. Less about control, more about cause and create. I think that's the ball you want to hit.
Okay, and on the cause and create issue, I'm entitled to discovery on that. I'm entitled to know what they did. They have this special tool. I'm entitled to know who was there, what they did. I list a bunch of questions that it just gives rise to the what they write in their affidavit. And I'd just like to correct, earlier I cited to a Keegan case. I misspoke, it's a Keach case. That's the case that I was talking about, the condominium documents. It was the Keach case, not the Keegan case. But altogether, the proof here is either is deficient, and also this motion is just premature in all aspects. I'm entitled to discovery. We're entitled to know what they did with regard to this schedule box.
Thank you very much.
Thank you, Your Honors.
Capital versus Greco?
Good afternoon, Your Honors. May it please the Court, Eric Mandel, Del Bello, Dinellen, Weingarten, Wise, and Whittaker, for the defendants' appellants. Your Honors, before I begin, I do have a slight hearing problem, so I apologize in advance if I ask you to repeat the question. It's made more difficult by the masks, but I do apologize in advance.
Don't apologize.
Thank you. Your Honors, the law is clear that for an individual to be personally liable when they sign an agreement on behalf of an entity, there must be a clear and explicit intention to be personally bound thereunder. That clear and explicit intention does not exist here. There is no separate signature line for Mr. Greco on the
But how
agreement.
about, Counselor, how about the fact that the agreement says including any person or entity affiliated? So isn't the argument that there's an affiliation and that's sufficient?
Well, yes, and the word affiliate is defined by Black's Law Dictionary as a corporation that is related to another corporation by shareholdings or other means of control, or a subsidiary, a parent, or a sibling corporation.
But we're talking about a person. It's not just an entity. It's person. So how isn't your client a person affiliated?
Your Honor, I'm not willing to concede that point.
Why
However,
couldn't we decide based on the fact that the individual signed the agreement, that by signing the agreement, he conceded that he was a person affiliated with the
Well,
corporate entity?
well, Your Honor, he did sign the agreement on behalf of 22 Bondo LLC. It does say, the agreement does say the undersigned 22 Bondo LLC, and then in parentheses it says, and any individual or entity affiliated with 22 Bondo LLC. But the signature line says Mr. Louis Greco. It says by Mr. Louis Greco, and underneath it, it says 22 Bondo LLC. So it's clear to me that he is signing solely on behalf of the entity in his corporate capacity and not individually, because there's no independent signature line, and it does not say individually. Aside from that point, the case law in this department and in the New York Court of Appeals is clear that when an individual executes solely as a corporate officer, they are not personally liable, even if the agreement says they are personally liable.
You know,
absent
I think
clear
it-
and, I'm sorry.
I'm sorry. I think that you're headed down that road in the sense that Mr. Greco signed the agreement, right? He also signed a guarantee, correct?
He did not.
He did not sign a guarantee.
No, he did not. He signed guarantees in connection with the loan that was entered into. He did not sign an independent guarantee where he individually promised to
Right.
pay.
So he separately signed a guarantee about the loans, not guaranteeing this
Correct.
decision.
It's a separate
this-
transaction,
right,
Judge, and,
right.
and which the plaintiff relies on in support of their assertion.
Wouldn't that be sort of an indication that he's not affiliated then? That why would he sign a separate guarantee if he could be on the hook for, do you know what I'm saying? Why would he separately sign a document?
Because in mortgage loan transactions, Your Honor, it's customary that a member or an individual will separately guarantee the loan, which is what happened here.
Right.
It has no bearing and no relevance on the agreement between 22 Bondo and GCP with respect to the commission.
If we find that, that it's not clear, what is your position as to whether it's ambiguous? Because any person or entity affiliated with the corporate entity, isn't there at least an ambiguity as to whether or not that would include the individual or not include the individual?
At a minimum, there's an ambiguity, and I can point to specific language in
Are
the
you
agreement.
acknowledging that there is an ambiguity, assuming that you win on your point that it's not as a matter of law that the individual is bound? Are you acknowledging that there's an ambiguity in how it should be?
Well, Your Honor, I feel strongly that the law is clear that he should not be held individually liable. But I will say that there are ambiguities within the agreement just based on the term of the use of the term borrower. If you look at the second paragraph of the agreement, it says borrower shall pay $150,000. Borrower is defined in the
But-
first paragraph.
I'm sorry, Counselor, we have to read the entire agreement, right? And the agreement includes language with respect to affiliation, so we can't ignore that language. It's all
No.
read together.
No, but what I was going to say, Judge, Your Honor, in the third paragraph, the term borrower, it says, borrower represents that it owns the premises. Mr. Greco does not own that property. 22 Bondo is the record owner of the premises. So right there is a conflict in the use of the word borrower in the second paragraph and the third paragraph. The second paragraph, the plaintiff would state that it encompasses Mr. Greco individually because he's affiliated. But the third paragraph, the term borrower owning the premises cannot include Mr. Greco because he does not own the premises.
Okay, you're going to have a chance to respond to him about it.
Thank you.
Good afternoon, Your Honor.
Counsel, who drafted this agreement?
The agreement was drafted by our client, GCP Capital.
By your client?
Yes.
And your client failed to define what they meant by affiliated?
The term affiliate is not defined, Your Honor, but we believe that it's clear and unambiguous on the face of the agreement itself. There's no question that GCP earned its commission under the agreement. GCP's sole duty under the agreement was to assist the defendants with obtaining this financing from Madison Realty in any amount or terms that defendants agreed to accept. The defendants don't dispute that GCP assisted. They also don't dispute that they agreed to the amount and terms of the loan that they closed on. So the commission was clearly earned by GCP in accordance with the contract. What's really happening here is that Louis Greco is trying to get out of paying GCP its
Well,
commission.
let me ask something. The law is usually very clear that someone who signs as an individual below the corporate name is not liable individually unless there's a clear expression or a clear intent for them to be found liable. Why should that term, any person or entity affiliated with the corporate entity, be sufficient to impose personal liability, where clearly, since you were the drafter, you could have put language in there that would have made it very clear that the individual is also liable or gotten a guarantee from the individual. Instead, there's language that's not entirely clear as to whether or not the individual is liable.
Your Honors, this is not a situation where Mr. Greco was merely an agent acting on behalf of a disclosed principal. If that were the case, the commission agreement would only mention 22 Bondo, but it doesn't. It has that language.
But I don't think you've answered my question, because it would have been very easy to put in language that he's also individually liable. That would have been very simple to put in. It would have been very simple to make it very clear. And instead, there's language that is not nearly as clear as to the liability of the individual. And you're the one who drafted, your client is the one who drafted the agreement. So why should we find, even at best, an issue of fact as to whether or not that was intended to include the individual?
It would have been completely unnecessary to spell out that Louis Greco is individually liable. The first sentence and the second sentence of the agreement make him a co-obligor with 22 BNDO. Otherwise, the phrase including—
What's the language you're referring to?
The undersigned, including any person or entity affiliated with, that's collectively defined as the borrower. And then the second sentence of the agreement—
Why isn't that, go ahead.
But counsel, isn't the undersigned, as you read that first paragraph, the undersigned 22 BNDO LLC? That's who the agreement refers to, correct?
That's correct, but then it goes on to say, including any person or entity affiliated with, and this is important.
So why not put in including Mr. Greco?
It goes on to say, the borrower. Hereinafter, it collectively referred to as the borrower, and the second sentence of the agreement says it's the borrower that agrees to pay GCP its commission, and then here we have Mr. Louis Greco signing as the borrower with 22 BNDO LLC. We don't believe that this agreement is ambiguous in any respect. We believe that Mr. Greco admits that he's the managing member of 22 BNDO. He signed the agreement on behalf of 22 BNDO.
Circling back to Justice Mendez's initial question to you, what meaning, what definition would you like us to give to the word affiliated?
Well, Judge, without being defined, then the courts generally look to the definitions in statutes, in dictionaries, and I believe at the end of the brief we cited the National Union case, which analyzes the word affiliate, and it generally comes down to indirect or direct ownership or control. So here, even using the plain colloquial sense of the word affiliate, Mr. Greco is that in every sense of the word. He is 22 BNDO. So on this point, we'd like to direct the court's attention to the Florence case, which is cited on page 10 of our brief, which we believe is dispositive of this issue. Louis Greco is certainly liable for the commission because he's a co-obligor, because he's a defined borrower under the contract. This is not an agency situation. We believe all the agency cases are completely an opposite. In fact, those agency cases draw the very distinction that we're drawing here when they make clear and say that this is not a situation where they were a party to the contract or where they were not identified in the contract. We have all those things here. So we don't believe this is a situation where somebody, an agent situation where there needs to be a superimposition of personal liability.
Thank you very much.
Your Honors, if I may respond to counsel's assertion that Mr. Greco is 22 BNDL LLC, I think that's an incorrect statement. In his affidavit, in the record, he says that he is the manager of one of the LLC members of 22 Bondo LLC. So the attempt to equate him as being the corporation is just not true. And his attempt to say that he is a co-obligor is belied by the record as well. He would need a separate writing to evidence Mr. Greco's independent promise to pay this debt. If I just may leave the court with this one quote from the Court of Appeals, everyone in business knows that an individual stockbroker or officer is not liable for his corporation's engagements unless
But
he
Counselor,
signed.
isn't your adversary correct? It's the affiliation language, person or entity affiliated, defined as a borrower, sort of take us out of those lines of cases, and we're sort of stuck with this, with the question, is Greco an affiliated person?
Your Honor, I would argue that he is not an affiliated person, but if the court
Oh,
were...
you mean he has no connection?
Well, you know,
He has
there's
no
no...
connection, he has no connection to this, to 22...
No, he does. He's a manager of a member. So in a broad sense, I guess I could concede that he may be an affiliate.
He's once removed, though. He's once removed. He's not directly with the 22 Bando LLC. He's a managing member of an.
He's a member. He's a manager of one of the member LLCs that comprise the the borrower. But then I'll go back to my earlier point.
I'm sorry, I just want to understand. So you're conceding that Greco is an affiliated person?
I am not conceding, but if the court were to find that, I still think there's ambiguities as to whether or not he would be liable under this agreement because of the use of the word borrower differently throughout the agreement. Borrower in the third paragraph has a different definition than borrower in the second paragraph. And I think there's ambiguities and intent issues here which were raised in the conflicting affidavits of the parties.
Thank you very much.
Thank you, Your Honors.
William?
May it please the court, Ira Goldstein with O'Connor, Hinson, Devney for defendants appellants. Your Honors, it is respectfully submitted that our cross-claims for contractual indemnification should not have been dismissed as a matter of law. The lower court focused in on warranty provision in the construction contract. However, that warranty provision relates to a defects paragraph in the contract. While there are 3 grounds for contractual indemnity, only one of those is a breach of warranty, and that warranty was for a year, the warranty to work for a year. So the 3 grounds were acts or omissions, which is a negligence trigger, and in fact, the lower court did find an issue of fact as to whether McGovern launched an instrument of harm and was negligent, so that should have been in play. The second ground is their performance or failure to perform.
Counselor, the contract here says that work will be deemed to be finally completed on the date December 31, 2010. No dispute here, the work was completed on that date, correct?
Well, I believe that wasn't answered. The exact date is really...
Well, it was over. The work's over. Performance of work has been completed.
Right, well,
Correct?
that's the end date. We do agree with that, but...
So why wouldn't the indemnification provision, why wouldn't we read that as reading the contract as a whole?
Well, in general sense, there's no precedent for an expiration of a contractual indemnity clause. These clauses typically run as long as that work is still standing, as long as that negligence is potentially still there.
Doesn't the indemnification provide, though, that it's required until the work is completed, is finally completed? That's the period for which insurance coverage / indemnification is required. So since the work was completed many years before, why would indemnification obligations still be ongoing?
Well, yes, the insurance procurement provision with respect to the complete operations and that work, yeah, that's a separate issue.
So the work is completed, so why should there be any more insurance obligation at that point once the work is completed?
Well, with all due respect, the insurance issue is a separate issue from indemnity. The only relationship really in this case is that...
But you get insurance to provide for indemnification obligations. They go hand in hand. The reason why you have insurance is to indemnify. If there's no longer any obligation to indemnify once the work is completed, you wouldn't require any more insurance.
Well, we're not necessarily asking for insurance coverage. That's maybe part of a separate DJ action. All we're asking for is indemnity if there is no
But again, the Section 9, the indemnity provision, as my colleague points out, it concerns performance of the work. Specifically, that's what it says. Work is completed. isn't it
Correct.
over?
Well, that doesn't necessarily mean during the course of the work. The performance of the work, the effects of that work remain long after the job is completed, is the case in this case, and the lower court did find that there was an issue of fact with respect to the raised in-ground lighting. So as we're just trying to say, there's no precedent for just looking at the indemnity provision alone. There's no precedent for that expiring. And we're not really focusing on the insurance because they could personally indemnify us regardless of the insurance provision. And otherwise, we could look at the termination provision in the contract, which at the very least should have raised an issue of fact as to the intent of the parties, because in the event that the parties terminated and went their separate ways.
But did that happen in this case? Was there a termination in this case?
No, but-
So isn't that a hypothetical, really?
It's a but it shows some intent where most of the other provisions would be moot, except
You're
certain.
saying that the insurance indemnification obligation should go on indefinitely. If 20 years later, if someone trips on the light, that the indemnification should come into play.
Well, if the contract doesn't specifically deem otherwise, it should be ongoing, because that negligence, again.
But couldn't you make the reverse argument, if that's really what was intended, that it should be explicitly expressed in the contract so that there is sort of a meeting of mind on those terms?
Well, maybe the contract could have been written a little clearer, but I think it's clear enough where there's only one explicit.
I got a very practical question, just to what Justice Kern just said. It's indefinite. Who's going to pay for that insurance coverage? Because your contract's over. I would think the contract that you have with the parties have all that play out in terms of the coverage issue and who pays.
Right.
So if you're going to say, yeah, if the contract doesn't say when it ends, it's going to go on indefinitely. So that's a huge expense, don't you think? 20 years out, paying for premium, somebody's got to pay it.
Exactly, but if the work was done negligently, I mean, they shouldn't escape.
Okay.
Thank you very much. You have time for rebuttal.
May it please the court, Michael J. Kazores from the Law Office of James J. Toomey for the respondent McGovern and Company. Your Honors, I think the questioning that you had for my adversary is quite on point. I think you're zeroing in on what the issue is. I want to just read for you one sentence from the insurance provision. It says, during the entire term that the agreement is in effect and until the work is finally completed, contractor should secure, maintain, and pay for the premiums for the following policies of insurance. Commercial general liability insurance, including contractual liability to specifically include the indemnification clause in this agreement. Until the work is finally completed. That's what the contract says. There's nothing here to indicate.
Well, that's built into the price you're going to charge too.
Absolutely.
Right? I mean,
Absolutely, Your Honor. And my adversary's talking about, well, if they did the work negligently, then they should be liable indefinite. However, the product's completed operation hazard provision extended that period. He would be correct if this accident occurred within 3 years after the work was finally completed. There's a specific provision that extended the insurance for an additional 3 years to give the owners that additional protection if 3 years after we did the work, there was some negligence.
Otherwise, you'll be assuming the duty of maintaining a property that you don't own.
Absolutely. We would be responsible forever. And, you know, that's just not what the intent of the contract was. And I think when we look at the contract as a whole, the indemnity provisions molded with the insurance requirement provisions that refer to each other, it's quite clear that when the work was finally completed, the indemnity obligation concluded. However, to the extent that the work was negligently done, there was the product's completed operation hazard provision that extended their protection for an additional 3 years. And given that the accident occurred almost 4 years later, there's no obligation to indemnify. Unless you have any other further questions. Thank you.
Thank you.
Just a couple points. Again, the termination provision, it provides that the indemnity requirement does continue once the project is finished. So
It only continues for another 3 years.
I'm sorry?
That's what the contract says. Under the warranties, it only continues for another 3 years.
Well, that's the warranty. The warranty is a defects provision and that's one facet of the 3 indemnity clauses.
That's as much as you get, 3 years, according to the contract. That's as far as it goes.
But that's only for insurance
Otherwise, it
coverage.
ends on December 31st, 2010.
Right,
when
but that
the work
assumes
is
that every
complete.
construction contract or a project will end, and we could count on our hands how many times that will happen.
But that's
And
what the
otherwise,
contract says.
the insurance and the indemnity, again, are 2 separate issues. I think we could analyze them separately. So I think the indemnity provision, it's clear that it rides on.
But again, the indemnification provision says performance of the work. The work has been completed at this point.
Well, it's during the performance of the actual work that the negligence existed. So I understand your point, but we still have the catch-all as a result of their acts or omissions. So
Thank you very much.
thank you.
Hernandez?
May it please the court, my name is Dan Ratner. I represent Con Edison on this appeal. The appeal arises from a personal injury action that went to trial. The plaintiff was working in a bakery and his hand became caught in a dough rolling machine. So there are a number of issues that we've raised on appeal, the first of which is that there's no evidence specifically that Con Edison did something wrong. A few days before the accident, there was a...
What about the testimony of your own witness, Chinchalin?
Yes, he testified that he was at the end line box out on the street, a manhole cover, and that they had to fix 2 sets of service lines going into the building.
Are you telling me that Con Ed did not know about the wiring issues?
Well, they couldn't have known what was going on in the bakery. Number one, the bakery...
Commercial establishment, they're in the supermarket. You don't think that they had some sort of duty to maybe do something with respect to the wiring issues, either let the other commercial establishments know about it?
Well, the problem was that they didn't have access to the bakery, and they didn't even know that the bakery was using what's called a 3-phase machine.
Right.
So they have to fix an outage, which is...
Generally, 3-phase machines, those are commercial type machines, right? They're not household machines, right?
That is correct.
So this is a bakery.
That is correct.
Didn't
Your Honor...
the Con Ed representative actually testify that he didn't need to tell the bakery because nothing bad could happen with this switch, which turned out to be totally untrue?
Well, what he testified was that a couple of different things could happen, one of which is the bad thing that did happen, that the machine could be going in reverse. He testified that could happen.
He said, it doesn't matter if I tell him or not because there's not going to be any bad consequences if I don't tell him.
I don't really think he testified to that effect. In fact, he testified that the supermarket was accessible, and he did go in there and he spoke to...
So why didn't he put a note on the bakery door then?
That's a fair inference to be drawn, so I'd like to, if possible, move on to the next argument, Your Honor, if it's okay with you. The plaintiff was aware that there were protective guards on this machine, that there was a slide.
Okay, then let me ask you about that, because the plaintiff was a baker who had been using this machine for many, many, many years, and nothing like this had ever happened to him. And how could he be aware that this is something that could happen? Well, all the years he's been using this machine, this has never occurred.
Well, because for one thing, he knew that there had been a blackout. He knew that the dough was not moving through the machine at the time in question. So all he needed to do was just reach down, flip the switch, turn the machine off.
And I assume that was your argument at trial, which is a fair argument, and the jury may have relied on what my colleague just brought out and come to a determination. I mean, is there no line of reasoning to support that?
Well, I think no fair interpretation of the evidence, since we are arguing weight of the evidence, would allow a jury to find that the plaintiff was not also negligent.
Plaintiff, who's a baker, not an electrician, would know to inspect to make sure that the rollers are moving the right way.
And he testified that he did it without thinking, even though he saw that the dough was not going through the machine and he knew that there had been a blackout. Two other witnesses testified that one would not put their hand near those rollers under any circumstances. We know that there were guards, there were yellow lines. We know all of that. So I don't think it's fair to interpret this evidence, this record.
But this is not a situation as in other unfortunate cases. In this instance, as I understand it, the machine can be used. You can put your hand up there because apparently, according to the baker, your hand wouldn't get caught up in the rollers because of the way the rollers moved, correct?
That is correct. That's why for him, he had used this machine many, many times without incident. But just because he had not had an incident in the past doesn't mean that, he would be absolved of his own liability.
What evidence supports your theory that he should have known? He's used this machine all his life and nothing has ever happened, but you're saying he should have known. And for the jury to not find that he should have somehow known that the machine would operate in a way that it had differently than it had all these years, what's the evidence that supports, that was admitted into the record that supports your position?
Well, I actually don't think the argument was that he should have known that the rollers were turning in the wrong direction. The argument is that he could have acted more reasonably in just simply turning off the machine before he put his hands near those rollers.
Well, sir, from the moment he turned the machine on to the moment the accident happened, how much time passed?
That's a good question, Your Honor. I don't actually have that. He testified that it was long enough to realize that the dough was not moving through the machine. That's the best I can say. That's the best I can say. And in that particular moment, we also know that the switch is literally right there at his fingertips.
Thank
In fact,
you.
when his hand got...
You'll have time for a rebuttal. Thank you very much.
Good afternoon. Herb Cabrera, appearing for the respondent. Your Honor, you hit the nail right on the head. This gentleman was an illiterate. He was illiterate, couldn't write English, couldn't write Spanish, but he knew how to bake. And he was baking for over 50 years. Since he was 15 years old, he baked, and he used that same machine. Had been working at this particular establishment since 2008 on a part-time basis and later on a full-time basis. Never, ever had any incident with this machine. The Con Ed electrician admitted on several occasions that he knew commercial establishments used three-phase machinery. The elevator in the corner of the building on 161st Street went down. And you know what he did? He went back into the manhole and changed the wiring to make sure that that elevator was functioning again. He went into the supermarket when he noticed that the supermarket freezers and the refrigeration equipment was not working properly. And what did he do? Nothing. What he did was he assisted the 3 or 4 electricians that the supermarket hired in order to
can you address, Counselor, I'm sorry to interrupt, can you address the issues raised by your adversary that Con Ed was denied a fair trial based on remarks at summation?
Judge, first of all, that was not preserved for appeal, as we indicated in the brief. Defense counsel objected during the course of the summation, and the judge gave a curative instruction, and defense counsel didn't object to that, and never preserved the issue for appeal. He never moved for a mistrial, and frankly, it is our contention that the comments themselves that are not of such a caliber as would require a reversal in this instance. With regard to the use of the machinery, I would say this, Your Honor, that there seems to be a misstatement on the record on appeal by defense counsel with regard to this quote-unquote guard that he mentions. The hand gets placed by the rollers, and Mr. Rivas, who is the owner and the manager of the location, says that he's used the machine in the past. When you put your hand by the rollers, there's no guard guarding that. The fingers get pushed back out. In this particular instance, because the Con Ed worker never notified, never posted anything on the door to the business, knew that the equipment was either going to be damaged, malfunctioned, or going in reverse as it happened with the conveyor belt, he just walked off the scene. And on page 717 of the record, we went into that line of questioning. I said, you walked off from the scene knowing that the lines were crossed. And after a great deal of going back and forth, he admitted, he says, yes, no. I said, yes, what? Yes. I said, yes, what? He said, yes. I walked off the scene knowing that it was reversed. So he acknowledges this. In fact, it is our contention that that was tantamount to gross negligence in this instance. Thank you, Your Honors.
Thank you.
If I may, Your Honors, I'd just like to also ask the court to consider reducing the lost earnings award to conform to what the evidence actually was in this case, which was that the total reported income by this plaintiff over a 4-year period before trial was $33,000.
Under our jurisprudence, can't testimony support a lost earnings number?
Well, I think when you're testifying about off-the-books income, that there's no documentation whatsoever. I don't think so, Your Honor. Plus,
But does that go to the weight, or does that go to the certainty of the award?
I don't think the award was established with reasonable certainty. I would say, in addition to the off-the-books income plus 3 meals per day, so for a period of time, a lot of this apparently seemed to be, the expert testimony seemed to be Mr. I'm sorry, I forgot his name. Mr. Berenson testified based on apparently what he was told by counsel outside of court. That's what the testimony was based on. The only evidence in the record was the tax returns, which show that he really was entitled to no more than a total of around $80,000 in lost earnings.
Thank you very much.
Thank you.
Board of Managers?
Good afternoon. May it please the court. My name is Stephen Kramer. I'm representing the plaintiff appellant. The notice of pendency that the plaintiff filed against the defendant's neighboring building was valid, and it should not have been vacated. The defendant was in the process of developing its property, and while it was doing that, it added to the party wall that was between the two properties. It increased the height, but it also increased the depth and the width.
Your side, though.
I'm sorry?
Your side of the party.
Oh, yes. So it went horizontally over the plaintiff's property, and that created an encroachment. So in our complaint.
So in other words,
Go ahead.
So in other words, what you're arguing is that the wrong that was committed was to your property, correct?
Well, this is the key. It was something that is attached to a party wall. And
But where was the wrong committed?
The wrong was committed, yes, it was attached to the party wall.
By attaching what was it, styrofoam, I think?
It was, yes, it was some kind of insulation.
The party wall that was on your side. So in other words, the wrong was to your property.
Well, I don't believe that's true, especially if considering this court's case in Lafayette from 1923. What is at issue is the easement. The easement, this is a party wall, so each party owns half.
It's interesting that you're citing to Lafayette when there's a much more recent case, which seems much more on point and even stronger than your case, where we vacated the notice of pendency, which is 801-803 LLC. In that case, there was actually an allegation of damage to the party wall, which we don't even have here. We just have styrofoam, which can be removed. And in that case, this court held that the notice of pendency should be vacated. And that was a stronger case than your case. So why wouldn't that case be controlling on this case?
That was not a stronger case, I don't believe, because there was no encroachment in that case. And we did cite to the record and in that case, in the complaint, they alleged that the addition to the party wall extended up to the face of the party wall, which they regarded as encroachment.
Correct me if I'm wrong, but the notice of pendency is to affect the defendant's property, is to keep the defendant from doing something on his property that's going to affect your property.
Yes, which is, that's why the important point here is it's a party wall, so that
So what is he doing on his property that's going to affect your property?
Defendant's property goes to the middle of the party wall, but they have an easement. The easement extends to the entire party wall. So therefore, the title to the to defendant's property includes the easement.
So this case is not about a fight about the easement, though. It's an allegation about the styrofoam that can be removed.
Well, as in Lafayette, this is a case that involves, among other things, the extent of the easement. Does the easement extend only to the party wall, or does it extend further? And this is exactly what this court found in Lafayette, where the question was, is it a party wall or not? And the court said, well, the defendant has a certain title at the beginning of the case, and at the end of the case, they might have a less of an easement than they did at the beginning.
So what is it that you want him to do on his property that would effectively then get rid of the notice of pendency? What is it that you want him to do?
Well,
what is this lawsuit? What would the lawsuit?
It's about removal from the joint, essentially shared property of the party wall.
Your
of
objection
removal
is
of the
to,
encroachment.
to something on your property, not to anything on his property, which is what the cases require.
But that's what I'm saying.
My colleague keeps asking about, because the law requires that you have to show somehow his property is affected, and your main allegation is that it encroaches on your property.
Well, there are two ways we're looking at this. One is that we're talking about the extent of his easement, which is part of his title. Under 6501, a notice of pendency can be based on claims that go to the title of property. The other is the enjoyment, the use and enjoyment and possession of the property. And in this case, removal of the insulation would require that it be replaced on the interior of defendant's building. Insulation is required by code. This is an essential part of their building. It'd be the same as if they put pipes.
You saying that he should have filed a notice of pendency against you then? Because it seems like that you may be encroaching on his property by putting up the styrofoam wall? That's not what you're saying, right?
No.
You're not inviting a notice of pendency to be placed on you, right?
I don't think so. No.
Okay.
What happened is the defendant decided to put its building system over plaintiff's property, attaching it to the party wall.
I'm really confused, because your complaint seems to be that this styrofoam encroaches on your property. That is what is offending your client, that it's encroaching on your property. So I don't know how that relates to their use of their own property, because the thing that you're claiming is the harm is the encroachment on your property.
Well, there's a whole string of cases by this court going back to 1902 to the Mueller case, where if there's a party wall involved and an encroachment, that the claim against the party wall to either alter it or remove it.
Yeah, but that's on the defendant's, that's on the other side encroaching on your side.
Well, it's attached, no, those are all encroachments that are attached to the joint party wall that extend over into the plaintiff's.
Yeah, so what part of the styrofoam originates from the defendant's, from the other side to come over to your side?
It is attached to the easement that the defendant has on the party wall.
Thank you. You have time to respond.
Thank you.
Good afternoon, Your Honors. May it please the Court. Eric Sherman for Respondent. I think Your Honors asked the right questions here. This is a case that
You have
involves
to file a
nothing.
notice of pendency against him, right? I mean, it sounds like that's where it's going.
You've given
right?
me ideas, Justice Owing. Thank you.
Counselor, the argument, could you address the argument raised? The argument, as I understand it, is because there's an easement that somehow affects defendant's title to possession or use enjoyment.
Well, the answer is that there's no easement implicated here. 801, 803 is directly on point, Justice Curran. And Justice Singh, the analysis begins and ends with what the complaint says. That's what 5303 Realty Corp tells us, that the court's analysis here is limited to the four corners of the original pleading. The original pleading starts at R35. The original pleading repeatedly alleges an encroachment and encroachment and encroachment. No mention of easements, no mention of anything more than that. This is about 4 inches of styrofoam affixed to a wall that happens to be the party wall. All that has to be done
On their
is
side.
Pardon?
On their side.
Right, exactly right. This has no bearing at all on our property. It's an alleged trespass or encroachment on theirs. That's the beginning and end of the analysis based on their own complaint. Braunston tells us also, Your Honors may be aware of Braunston, I know it was cited in 801, 803, that if it's just an encroachment and not an encroachment plus, then there's no basis to file a notice of pendency. There's a whole line of cases. In addition to that, there's also an independent basis to cancel this notice of pendency. Number one, it expired by its own terms, and appellant never moved to put a stay to the cancellation or the expiration of the notice of pendency. And there's clear statutory provisions that say that you cannot resuscitate a notice of pendency once it's expired. That's an independent basis. Beyond that, we also have a discretionary basis for cancellation of the notice of pendency because appellant commenced this action in August of 2017 and did nothing for years. The first thing they did in this case was to file a request for a preliminary conference in July of this year. This was a situation where the notice...
Isn't the argument that there wasn't much they could do because of the bankruptcy proceedings, et cetera, et cetera?
Sure. It's a rabbit hole, Your Honor, but I refer you to my papers. There's a very lengthy discussion about how this property was not at all implicated in any bankruptcy proceedings here. There was never a stay of the bankruptcy proceeding, something that the justice below correctly recognized. That was a complete red herring, and beyond that, the bankruptcy proceeding wasn't even commenced until about a year after the lawsuit was filed. They throw a notice of pendency against the property and sit on their hands for 4 years. That's bad faith, and that's why we're also entitled to attorney's fees and costs here. Your Honors, unless you have any further questions.
Thank you very much.
Okay.
I would just like to stress that an encroachment, by its very nature, is something that's on plaintiff's property. If that fact alone ruled out a filing of a notice of pendency, then there is a whole string of cases decided by this court that are being ignored.
I'm not sure I agree with you, counsel. It seems to me that the law is really clear that it has to affect defendant's title, possession, use of its property.
Understood.
That's the law, right?
Yeah, that is the law, and one way to do that is by affecting the title, which includes the easement, the party wall easement, which is why...
Bronston, which is mentioned by your opposition, says that there's no right to a notice of pendency where it's just based on encroachment. That's black letter law.
Well,
This allegation, this case, it's an encroachment.
Well, an encroachment with a party wall. Bronston does not even involve construction. It's not a case that involves a party wall. That's a case that involves a nuisance from water. So
Any
I
other
don't believe it's
questions?
the opposite.
Sir, the questions or the cases you're referring to regarding party walls, do they come up in the context of a motion to vacate a notice of pendency?
Yes, they do. Yes. I urge them.
Okay, thank you very much.
Thank you very much.
Comptroller?
Good afternoon, Your Honors. I'm Edward DeLito of Storch Byrne LLP, representing FX Analytics, the key town plaintiff and the appellant herein. Now, my client identified a scheme by which the Bank of New York Mellon was defrauding the public and the private customers by foreign exchange.
Weren't your claims under the State Act, weren't they dismissed?
They were dismissed, Your Honor, after New York State took control of the claim.
Yeah, but am I wrong that the allegations that remained were breach of contract, breach of fiduciary duty, nothing to do with the act, correct?
Not true, Your Honor. The court below, on page 13 of the record, stated the court takes note that the funds, the city funds, do not deny that the scheme uncovered and brought to light by FX formed the basis for all the claims in the action, including the funds contracted common law claims. It was the same set of facts, the same scheme.
It's the same facts, but different claims.
A different claim, but the same scheme. And the nature of the claims...
And I'm sorry, I still have one more question. I don't understand why the appeal wasn't perfected, where maybe this issue could have been addressed years ago, I think what you're saying.
New York State superseded my client's claim. New York State, under the statute, is in sole responsibility for the direction of that lawsuit at that point in time. The statute provides that once New York State supersedes the key TEM claim, it has primary responsibility. If it merely intervened, would have shared responsibility with my client. The statute provides also that my client cannot bind the state. My client had no ability to appeal if the state decided not to. And frankly, the state's decision makes a lot of sense as a non-legal matter. I mean, there are frequently questions of allocation of resources.
Counsel, was your participation in any of these proceedings limited or restricted?
I'm sorry, I didn't.
Was your participation, once the state and the city intervened and superseded, was, under the statute, you still are allowed to be participating? Was your participation in any way limited or restricted by these superseding complaints?
Well, the superseding complaint was the governing complaint, the operative complaint.
I'm just asking a simple question. Was your participation restricted?
Yes, in the sense that it could not countermand what the...
I'm sorry, I didn't hear you.
In the sense that it could not countermand what the state was doing.
Right.
So yes, it was restricted to that extent.
Other than that, you could still participate in the proceedings, though, right? I mean, you're still actively involved.
Well, we were contributing, certainly, but not controlling the proceedings.
Well, my next question is that, and I thought about this because I think that Justice Below mentioned this, when the decisions were to dismiss the claims, the Act claims, did you think about appealing that? I mean,
I'm sorry, Your Honor?
Did you think about appealing that? You couldn't take the appeal on that?
Your Honor, first of all, there was no reason to appeal because the same scheme was still the subject of a viable claim. Under the language of the statute, it's clear if the Attorney General elects to convert the key temp civil action into a Attorney General enforcement proceeding, then the person or persons who initiated the key temp civil action collectively shall be entitled to receive between 50 and 25%.
Thank you. Are there any other questions up from the bench? Okay, thank you very much.
Thank you, Your Honor.
The next case is Sejas versus Mendelo.
May it please the court, Russell Bogart from Kagan, Casperson, and Bogart PLLC on behalf of the appellant, Sejas LLC. Sejas requests that this court reverse the trial court's ruling dismissing Sejas' claims for breach of fiduciary duty and unjust enrichment filed against the Mendelo defendants. The lower court erred for two principal reasons. First, the lower court errantly held that Sejas' claims were derivative and belonged to FGLS. This was incorrect because Sejas was uniquely and disproportionately injured compared to at least 39 of FGLS's other 40 members.
Counselor, go ahead. Go ahead. No, go ahead.
When the liquidation plan was put up for approval, you objected, correct?
Yes.
And did you take the position at that time that you wished to pursue a derivative action?
There were other claims that were derivative, and we had filed this lawsuit. And in that,
in other words, you're not taking an inconsistent position here. Is that your argument?
No, Your Honor. We typically, when a case is brought derivatively or directly, the court could dismiss and say you had to bring in the other capacity. FGLS had filed that motion seeking an order precluding any future litigation being brought. So under the CPLR, we had to protect our position in the event that the court disagreed with us. We said it was direct, but if the court disagreed with us and said it's a valid claim but it should be brought derivatively, we would be barred. So under the CPLR, we said that we're preserving our right if you disagree with us. But we filed this lawsuit, so the court would see the lawsuit.
With respect to your initial statement that you're suffering a unique harm, what about the well-established principle in the First Department that to the extent that you've asserted a direct claim, if it's embedded in an otherwise derivative claim, that you cannot then bring the direct claim? Even if your harm was unique, isn't it clearly embedded in any harm that would have been suffered by the company as a whole and therefore barred?
Yes, Your Honor. Thank you for asking that question. In all the unique cases, you could argue that the harm was embedded in the corporate harm. All those cases cited in page 28 of the moving brief. Here, it was clearly unique because 39 of the 40 members suffered no harm. Their capital accounts weren't diminished.
But didn't the corporation suffer the same exact harm that you're claiming you suffered?
No. In the inter-account decision, the federal court used simple hypotheticals involving fictitious investment vehicles to illustrate its points. Let me give it a shot because I think this demonstrates Say-Just position. Imagine FGLS only had 4 members, each of whom advanced $1 million into FGLS. FGLS in turn turned all the money over to Madoff and it was all gone. Also, for simplicity purposes, imagine that Picard's able to pay 100% of all valid Blimis claims. However, Picard disallowed Say-Just advance into FGLS because the money had been commingled in the CNP account through which the Mendelos had received millions of dollars in kickbacks. Now FGLS has a $4 million real-world loss, but only a $3 million claim, which Picard could pay that $3 million. However, FGLS goes to the trial court and says, shouldn't we apply the same accounting rules that Picard paid to determine how the $3 million should be divvied up? And the trial court said, yes, that's the only result, proper result. So the 3 other members of FGLS get their $3 million under that hypothetical, and Say-Just would get absolutely 0. And their position is, under this set of facts, that Say-Just has no direct injury. It's an absurd and draconian result, and that's what happened here. The accounting is a bit more complicated because there were other members from FGLS who received an extraordinary high amount of fictitious profits. So there's a number of different complicated accounting principles in effect, but the hypothetical that I posited to you is what happened here. We also cited in our brief a number of cases that the respondents never addressed, where New York and Delaware courts have viewed in simple investment pass-through vehicles as the harm being directly inflicted upon the member. We cited to Royal Park, we cited to other cases. And in each of the unique harm cases, the harm always involves the corporations. You could always say that it's embedded or somehow related to the corporation. The distinction that Judge Cohen raised in the lower court was not a valid one. He said those cases involved an intentional harm. But this court's precedence says that it's sufficient for breach of fiduciary duty cases just to plead the unequal treatment. And
But don't we also have cases that say if it's a breach of fiduciary duty claim, it's not a proper derivative claim?
No, because the breach of fiduciary duty is owed to the members of FGLS. The managing member is Nancy Mendelo, and she controlled the entity. She owed the direct fiduciary duty to FGLS. And also the intent here.
Right, so what about the line of cases that say where the claim is a breach of fiduciary duty claim to the corporation, that is a direct claim, not a derivative claim?
Right, but there are also cases that talk about the controlling member, Nancy Mendelo, managed FGLS. And this court's cases are clear. The managing member owes a direct fiduciary duty to the minority member. And the unique cases involve that principle, as this does.
You'll have time for rebuttal. Thank you very much.
May it please the court. Good afternoon. Richard Schaefer from Schaefer, Vanalia, Handler, and Fitzsimmons on behalf of the respondents. Your Honors, I didn't come here to argue a hypothetical case or a case that could be put together with possibilities almost like a novel. That effectively, with all due respect to Mr. Bogart, for whom I have great respect, is what he's asking you to do. This is the 4th time that Mr. Warshaw, through Say-Just, has attempted to get additional money from the Madoff estate based upon the rollover amount. The first lawsuit didn't relate to the rollover amount, but rather was a lawsuit brought by Mr. Warshaw in 2010 in the Supreme Court, New York County, in which he claimed that Stephen Mendelo, who was then alive, was guilty of fraud, breach of fiduciary duty, and other torts. That case was settled on confidential terms 2 years after the Madoff, 2 years or 3 years after the Madoff fraud was discovered. FGLS made extensive efforts when Stephen Mendelow was the managing member during his lifetime to pursue the rollover amount from the Madoff estate. Mr. Picard, as the trustee, made a determination that although FGLS was entitled to other monies aggregating in excess of $3 million, that it was not entitled to the rollover amount because it represented fictitious profits in the Madoff accounts. After he made that determination, there was an appeal initially to the district court in the Southern District, which affirmed his finding. The case then went to the Second Circuit Court of Appeals, which also affirmed Mr. Picard's finding that the rollover amount was fictitious profits and that nobody would get anything as a consequence of them. Warshaw then sought to compel FGLS to pursue the very claims that he's now trying to assert here on the baseless theory that Stephen's widow and daughters somehow leveraged the rollover amount in the context of their...
That's going to the merits. Before we get there, can you address the direct versus derivative? Because as I understand the argument, since the injury was uniquely to plaintiff, that takes it out of the derivative and puts it into the direct.
Your Honor, thank you. The answer to that is that he has suffered no unique claim, that there were other members of FGLS who were similarly situated. It is not a unique claim. It is a derivative claim, and it is a claim that is an FGLS claim, period. Mr. Warshaw argued in the Supreme Court of New York County before Justice Cohn in the FGLS proceeding that this was a derivative claim and that he wanted Justice Cohn to compel...
Yeah, but I think there was a response to that, to my question, that he was, he had to hedge his bet in essence, right?
Well, he didn't explain that then, and he didn't explain that until after, number one, Justice Cohn granted the petition for Mr. Turchin to go forward. This court affirmed that decision unanimously, and since the submission of our brief, the New York Court of Appeals has denied leave to appeal the FGLS decision. So that now this is, again, the fourth time he's trying to do this. The entire theory of the case now being pleaded is speculative in the extreme. There is no evidence that Mr. Mendelow misled the trustee in terms of the $9+ million settlement. And it's based on a fundamental mischaracterization of the nature of the damages that was sought by Mr. Picard against the Mendelows. However, this court need not go down that path. Setting aside the speculative and basis theory that underlies his claims against Stephen Mendelow's daughters, as Justice Cohn correctly decided, Say-Just has no standing and it has not stated any claim in any of its causes of actions. The basic argument is that Say-Just has no standing because these are derivative claims. To the extent that the rollover amount claim has any value at all, it would be an FGLS claim, which would have to be pursued by FGLS and not by Say-Just. In that regard, and I will repeat it, Say-Just, in fact, made that very application to the Supreme Court, New York County, Justice Cohn, in the FGLS case. And in fact, Justice Cohn said that Mr. Turchin, who was the new managing member of FGLS, acted appropriately in making a decision not to pursue that litigation for all the reasons that people don't pursue litigation.
Anything additional that you wish to add?
I would only add that neither the fiduciary duty claim nor the unjust enrichment claim, both of which, are derivative claims, have any value, and they have no value because nothing that Nancy Mendelow could have done would have rewarded or brought any additional money to either FGLS or SayJust. Thank you, Your Honor.
Thank you very much.
There's been a lot of discussion about what positions were taken in another case. What's missing here is the record in the other case. They never introduced it. Instead, they're asking the court to accept his characterizations of what was said in the other case raised on appeal. That's not proper. Secondly, with respect to the unique harm, I think the court got it, but I just want to explain something.
But let me stop you there. The response is that, in fact, it's not unique because maybe your allegation is that you suffered greater injury. Others also suffered the same harm. The harm was, therefore, derivative and not directly to your client.
Let me address that, Your Honor.
Thank you.
Because the standard is unique or disproportionate. So it was clearly disproportionate. SayJust lost $1.7 million. Its account went down to $84,000. What happened was C&P and 3 other members of the 41 members had loaned money to C&P. They had individual loan contracts. Then those monies were moved into FGLS because Mendelow was afraid that he was running afoul of the securities laws. SayJust enters into a separate contract with FGLS. The other people enter into their own separate contracts for their membership interests. They treat it as all one big rollover, but it was really 4 separate transactions. The 2 of those members, SayJust and Sands, had positive capital accounts that got wiped out. The other 2 members had negative capital accounts, meaning they were very large winners of fictitious profits. So when the trustee backed out the rollover into their accounts, there was no profit to or no principal to absorb the loss. So it's really SayJust and Sands out of 41 members who had a capital account eliminated. We cited to many cases where you have minority shareholders who have one treatment, and the rest of the people here, those who invested after the rollover, have a different treatment. If 2% of FGLS's interest suffered an elimination of its capital account, they are minority shareholders who suffered disproportionately and uniquely and should be able to seek redress from the court.
Sir, is this case distinguishable from Udell versus Gilbert?
Yes, I don't remember the facts of Udell right before me, but I believe that's one of the cases where there was the equal harm to the shareholders in terms of their membership interests. So for instance, if there's an accounting fraud and somebody steals money from the company, all shares suffer the same. Here, it's SayJust loses $1.7 million. That is completely distinct. On the speculative issue, Judge Cohen actually rejected that position. He said, discovery may very well prove Picard would have done something very different. In terms of fiduciary duty, it hasn't been addressed, but there's a clear obligation for fiduciary to disgorge any material benefit.
Thank you.
Okay.
Thank you. Are there any other questions from the bench? Okay, thank you very much. The next case is Chrysler versus BU Realty.
May it please the court, I am Michael Littman from Sedrain, Schwartz-Sedrain, Pembersaker, and Littman LLP for the appellants. Defendant's appeal concerns 2 main arguments. The first is that the trial court lacked subject matter jurisdiction as rent stabilization is statutorily based and the corporate tenant should not have been determined to be rent stabilized. And number two, the Housing Stability and Tenant Protection Act of 2019 should not have been
I
applied.
don't think there's any dispute about the Housing Stability Act issue. Your co-counsel has conceded that issue, so I don't think we have to spend a lot of time on that. So let's focus on your first issue about the corporate tenancy. Why isn't this entire argument precluded by law of the case?
Because subject matter jurisdiction can be raised at any point in the litigation. It's not waivable.
Okay, but counsel, this is a case where the issue that was being litigated before, and I believe both sides made motions for summary judgment, was whether or not there was rent stabilization protection. That issue was thoroughly litigated. It came up to the First Department. The First Department affirmed the finding. It went down below. And then this issue about the corporate tenancy was only raised in a motion for renewal. Why then do you have a right now to raise it after all these years of litigating, never having raised it before? Why doesn't the law of the case overtake your claims about the rights of creating a rent stabilization?
Your Honor, it's our position that the Fox case was decided after those summary judgment motions were submitted to the court, and that the Fox...
But is Fox new law? Because my recollection of reading Fox is that we based a decision on Manchurian, which is really old precedent.
It's our position that Fox construed the first requirement strictly for Manchurian, and that it expanded on it, and that also the Fox case also dealt with the J51 issue, which is also clearly a part of the instant litigation as well.
Counsel, I was actually on that Fox case, and it was clearly an application of pre-existing law, which had existed for some time, about corporate tenancy and what would be required to obtain rent stabilization in those circumstances. There was nothing new about its application in that case. So I don't believe there's any validity to your argument about new law. And that being the case, again, we already specifically held the First Department that the tenant is entitled to rent stabilization based on all issues that had been presented to us. Why do you get a chance now to bring up a new issue after that choice you made in terms of litigating the case and proceeding?
As I said, Your Honor, we believe that it's a subject matter jurisdiction question, which could be raised at any time, and that the lower court did not have the right to determine that a corporate tenant in this situation is rent stabilized.
I'm sorry, I keep throw these words around. How does that go? Subject matter jurisdiction goes to the competence of the court to hear a particular kind of issue. Clearly, the court had the authority and ability to hear the issue and decide whatever it decided. Does that really go to subject matter jurisdiction?
We believe it is, Your Honor, that the...
Isn't the Supreme Court empowered to make determinations of rent stabilization status?
It is, Your Honor.
And if it is, then it doesn't go to subject matter jurisdiction, correct?
I disagree that it does go to subject matter jurisdiction, that the corporate tenant under the rent stabilization statutes cannot be determined to be a rent stabilized tenant in this situation, and that's the subject
That sounds
matter.
like a classic declaratory judgment action to me.
I'm sorry, Your Honor?
It sounds like a classic declaratory judgment action.
It is. And as this court has held, corporate entities that do not name individuals in the lease and where there is a risk of a perpetual tenancy, that a corporate tenant cannot be determined to be a rent stabilized tenant. Rent stabilization cannot be created through waiver or estoppel.
Didn't you have to make that argument when there was a prior determination made that the tenants there, the individual tenants there would be deemed the occupants? Wasn't that the time to raise that issue?
Perhaps.
And to appeal that determination?
Perhaps, Your Honor, and we didn't think that there was a final determination until the most recent decision, which we are here today, Your Honor.
Second summary judgment. Okay, thank you very much.
Thank you.
From opposing counsel.
May it please the court, good afternoon. My name is Damon Howard of Efron, Mendel, and Howard for the respondents. As this court has rightly pointed out today, I think that firstly, this argument is procedurally not properly before this court today for a couple of reasons. The first, as this court has noted, they are barred by the law of the case from raising this argument, having relied on their position that they conceded the rent-stabilized status and the right to a rent-stabilized lease.
Let me ask you, what about the proposition that you can't create a rent-stabilized status by estoppel or waiver?
I completely agree, and I think that we can both simultaneously believe that Fox was a correct decision under those factual circumstances, and that there are very distinct factual differences here.
Assuming for purposes of argument that Fox would apply in this case, but for the procedural posture, what's the procedural posture that prevents Fox from being applied now in this case?
Yes, Your Honor. So the summary judgment decision by the court specifically noted this particular issue and indicated that to avoid that issue, that the individuals would be named on the lease which the defendants are required to issue to the individual rent-stabilized tenants. I would also note that there is a clear precedent in the First Department that says this is, in essence, a non-primary residence argument. By statute and by precedent, that is not a matter that you can bring before this court or properly raise without having first given the statutorily required what's known as Golub notice, notifying the tenant 90 to 150 days before the expiration of a lease that you're not going to be renewing them. And in that notice, they would have indicated that it was on the grounds that it was a corporate entity. And this court in 520 East 81st v. Lenox Hill clearly stated that you cannot bring a non-primary residence proceeding before the Supreme Court and thus circumvent the statutory obligation to give a notice of non-renewal or a Golub notice. I would also note factually, the Fox case is clearly in opposite to the current case and to the current facts. Firstly, I would note that in that case, you had a tenant that in 2008 asked the landlord, can I have a new lease? And can I have a lease in this corporate entity's name? At that time in 2008, notably pre-Roberts, the J51 was not in effect for that building. So you had a building that was not subject to stabilization, and you had a tenant of their own volition saying, give me a new lease. And in this case, you have a KEGA SP, the corporate entity, was always named at all times in each of the 4 leases, and each of those 4 leases was issued by the landlord post-Roberts in clear violation of the Court of Appeals holdings in that case. I would also note that as a factual matter, none of those leases reflect the owner of the property on the lease. Each of those leases, as noted by the trial court in the decision on the motion for summary judgment, notes Paul Bogoni, not BU Realty Corp., which is the owner of this property. Thus, to the extent that they seek to rely on these leases to say that there's a corporate entity named on the leases, they are not valid leases, aside from the fact that they were born out of fraud at all relevant times in this litigation. Unless there are any other further questions, I would rest.
Any other questions? Okay, thank you very much.
Thank you.
Your Honors, I would just like to speak to the Golub notice requirement. We're not seeking to terminate a tenancy. We're asking the court to find that the lower court did not properly find that the corporate tenant could not be a rent-stabilized tenant of this specific apartment. We're not seeking to terminate the tenancy. We're basically saying that the corporate entity is not a rent-stabilized tenant. And if the court has no further questions, Your Honor,
Thank you very much.
thank you.
The next case is Morley versus Blackstone.
Good afternoon, and may it please the court. My name is Richard DiPonto, and I represent the plaintiff appellants in this case. The issue in this appeal simply is that the defendants, as the moving party under summary judgment, failed to establish their prima facie burden of addressing and submitting affirmative evidence addressing each and every allegation contained in the plaintiff's bill of particulars and complaint. At the outset, it's axiomatic that in a property liability case, defendants are liable if they either had actual or constructive notice of the defective condition or if they created the condition. In situations where it is alleged that the defendants created the situation, the defective condition.
So what's your claim here, counsel? Are you claiming cause and create?
That is part of the allegations, Judge.
Which seems to be the theme of the day in any event.
Yes, Judge. That under the American Standards for Testing Materials, the ice skating rink had a
So
certain
why
standard.
didn't they at least make a prima facie that they did not cause or create it based on their testimony about how it was assembled and maintained?
I'm sorry, Judge?
How did they not at least make a prima facie as to the cause and create based on the testimony they provided from the rink manager that the rink was properly installed by a team of professionals and continuously inspected for defects after installation? Why isn't that prima facie showing?
Sure, Judge. The testimony that you're referring to is Andrew Frey. He's the general manager of the rink who has absolutely no experience in the installation of these ice rinks. The defendants have their own separate division of a specialized crew who go around the country and install these rinks throughout the country. It's a seasonal ice rink. Mr. Frey does not have any knowledge as to the proper procedure to install the ice rinks. That's left to a separate division. The defendants had a duty to come forward with affirmative evidence, either through an expert affidavit or an affidavit from a member of this specialized crew that said, here's what the proper standard is, here's the procedure.
Why isn't it enough for them to say, we hired professionals to install it, the professionals did install it, and it was installed professionally, and we paid for a professional installation? Why isn't that enough for a prima facie?
Because that's not affirmative evidence with somebody with knowledge, Judge. This is simply Mr. Frey saying there is a separate division who comes in, and he doesn't say that it was installed properly. He says that his job is to go and inspect after it's been installed to see whether or not, after it's been installed, there are defects that occur. Mr. Frey, and he testified, he may be there during the installation, but he's there as a helping hand. He's there to gather things and help carry stuff. He's not there to...
Counsel, let's assume for argument's sake that a prima facie was made on this issue. Did you raise an issue of fact?
Yes, Judge, I believe so.
And how did you raise an issue of fact?
We had an expert engineer who looked at photographs of the location of where the injury occurred, and citing the American Standard for Testing Materials, said that it didn't conform to the American Standard for Testing Materials.
In other words, they weren't properly fastened or secured. Is that?
It wasn't flush, it wasn't radius. There were certain provisions that, under the American Standard for Testing Materials, it didn't comply. So
you also had the testimony of someone that was there too, one of the workers there, saying that they thought they saw a gap or something, right? Did I read that correctly in the record?
I'm sorry, Judge?
That there was a worker that assisted the child and looked back and saw something of a gap or...
Well, Judge, that's another issue and goes to the defendant's failure to establish that, one, their inspection practice, and two, the location of the incident altogether. The infant plaintiff testified specifically where her thumb got caught on the dasher boards. She testified that there are doors that open into the ring to allow the Zamboni to come in, and that her thumb got caught in one of those dasher boards to the door that opens. It got caught, and she continued to skate on where she eventually fell down. Now, the defendants say, there's no question as to where this accident occurred because all of their witnesses say it happened where she fell. But not one of the defendant's witnesses observed the accident. The only person on the ice, Miss Bickley, testified that she wasn't near.
Didn't the employees observe blood on the dashboard?
Yeah, they did, Judge, yes. But they observed blood because my client's dominant right thumb was partially amputated. It's going to bleed. That doesn't establish where the injury took place. You have essentially an ICE monitor with 2 weeks' experience is providing an expert opinion as to blood trails, saying that it couldn't have happened where she claims because there would have been a blood trail.
Can you address the PTSD claim, please?
Well, Judge, what I would say to the PTSD claim is that the lower court didn't rule on the PTSD claim. Essentially, all the lower court said was that the defendants can't be liable because there was no notice. They didn't address whether or not they created it, and because they dismissed the case because there was no actual constructive notice, they never ruled on the PTSD claim, so that issue is not before this court.
Okay, you have time for rebuttal.
It's okay. May it please the court, Matthew J. Kelly on behalf of the defendants. Judge, we proved that the inspection of the premises was done properly by the fire department and the building department after the construction was done. And the general manager, Mr. Fry, is not a novice. He's been the general manager of 4 rinks in the metropolitan area. He's familiar with how the boards are constructed. We put in an affidavit at 425 of the record with regard to that, and he testifies fully as to the inspections that are regularly conducted.
Okay, let's assume there's a prima facie. Did the plaintiff's expert raise an issue of fact with respect to the cause and create theory of negligence by saying things like, or opining that the board wasn't properly fastened, there was a significantly uneven gap, et cetera?
The lower court rejected that opinion in full, and this court should as well. That particular expert didn't set forth any basis for any inspection he ever did. He didn't include any objective evidence of any photos. What expert
But
goes to a
does that go to the weight as opposed to just rejecting the opinion out of hand? Doesn't that go to the weight?
No, there's cases in this department, Your Honor, with regard to that very matter, with regard to when an expert says speculative things, you don't have to rely upon them at all, and you can throw that opinion out.
What about the testimony of the employee that there was, after the fact, seeing it after the accident, that there was a crack?
The rink monitor, Ms. Bickley, said that she regularly inspected the rink during this hour time that the rink was going on, didn't notice any defects, said the...
But didn't she state that when she looked at it after the accident,
yes,
she saw a board separation of about 1 inch?
she indicated that there had been a board
So
separation.
wouldn't that raise a factual issue as to the cause and create course of action?
No, because there's 25 to 50 people on this rink during the course of an hour and a half activity, and the testimony is that if you jump into those boards and crash into them, you can have an impact on them, and that's
You're
why
saying
we...
that's just a risk of skating, that someone could jump into them, it's going to create a crack, and someone could get part of their thumb amputated. That's just something that could happen, even if everything is properly installed, those cracks will create.
That's part of the assumption of risk of ice skating on a public rink, that you can't control everything that happens.
And that you can't keep these boards together, that inevitably during the course of a day, they're going to crack open no matter what you do.
Well, you're gonna have to regularly inspect them, and we've proved that we did, but we can't prevent them from moving from time to time, and that's what the testimony is. So I submit to you, Your Honors, that we've demonstrated our entitlement to summary judgment, and you should affirm the lower court. Thank you.
Thank you.
Your Honor, just a couple of points. First and foremost, the affidavit of Mr. Frey that was referenced by counsel in support of the motion for summary judgment, not one allegation in a paragraph says that he's familiar with the installation of these boards and that it was done in proper procedure, proper standard. That's because he doesn't have knowledge of that. That's a separate division, and they didn't provide any affirmative evidence that they did not create this condition. And essentially, they're trying to improperly shift the burden on the plaintiff to come forward with evidence.
Sir, did your expert disclose the factual basis for his or her opinion regarding the negligent installation of the dasher boards?
So, Judge, the day after the incident, the plaintiff's father went to the ice rink and took pictures of where the incident occurred. So my expert had the ability to look at these photographs of the location the day after it occurred and basing his opinion largely on this photographic evidence. Now, because it is a seasonal ice rink that comes down, my expert was not able to review this ice rink in the same condition it was, but did have photographs. And as the court did state, that my client, the lower court never determined that my expert was not qualified to make this opinion. And any issues that the counsel has to my expert goes to the weight, not the admissibility of his testimony. And as to Ms. Bickley, she never testified that she inspected any of the boards prior to the accident. In fact, when asked during her deposition, she specifically asked, what training did you receive? What are your roles and responsibilities? Not once did she ever say part of her responsibilities was to inspect the boards. And in
About
fact,
the argument that this condition could be created by skaters randomly crashing into the boards during a skate, as opposed to the negligent installation of the boards in the first instance?
Sure, Judge. That's why there's two prongs here. There's a negligent creation, and then there's the failure to maintain and to inspect. And that's part of the constructive notice that they should have had, because the defendants failed to establish their inspection process. You have another ICE monitor who was specifically told that inspecting the boards was not part of her responsibilities. So we have no testimony that any of the boards were inspected while skaters were on the ice, and counsel admits that when skaters are crashing against the boards, this situation can happen.
Thank you very much. Katsky-Corins versus Moskowitz.
Good afternoon, Your Honors. May it please the court, my name is Robert Abrams on behalf of Katsky-Corins, the appellant. The lower court erred when it denied our motion for summary judgment on our account stated claim and our breach of contract claim. It erred because it is undisputed that the firm performed services pursuant to 2 engagement agreements, that after we provided and delivered our June invoices to the defendants, they partially paid them. And it is undisputed that there is not a single document, not a single written objection to our June 2019 invoices or to our subsequent July 2019 invoices.
Was there a verbal objection to your invoices?
No, Your Honor. There are no written and no oral objections to our invoices. And in fact, we sent out 4 reminders, Your Honor, in August, September, October, and November, attaching all the invoices again and again and again, saying, here are the invoices, please pay them, and no response whatsoever. So without any written objections to any of our invoices.
What inferences can we draw from the fact that, in fact, she appeared unhappy with counsel? She decided in August, early August, to make a change in counsel because she believed she was being overbilled. Would that be sufficient, at least, to create an issue of fact as to some invoices?
No, Your Honor. Clients switch firms all the time, okay? And that does not necessarily mean that the firm's invoices
and they switch firms because they've been overbilled, for example, or they believe they've been overbilled. I mean, that's probably not uncommon, no?
Well, no, Your Honor. In this case, no, because in this case, when the client switched firms, they were only aware of the June invoices, okay? The August invoices had not even been delivered. I'm sorry, the July invoices had not even been delivered to the defendants. So let's talk about the June invoices. The June invoices were actually partially paid. And those June invoices were delivered on July 7th to July 8th. And what happened on July 8th? They continued to use our services, Your Honor. They were happy with our services, okay? And that shows in the time records between July 7th and through August 6th when our services were terminated. They were not even aware of the amount of the July bills until August 12th, okay? And they weren't even aware that we were providing them with a courtesy discount until August 12th. So at the time they
Well, would the
terminated our
courtesy
services.
discount suggest that maybe there had been discussions about overbilling and the law firm decided to discount the bill by, it was $25,000, I think?
No, Your Honor, there were no conversations at all, okay? We provided the bills to the defendants. They had an opportunity to object to them.
Wasn't
And in
there an
fact, the
explanation,
discount
counsel?
was afforded to the
Counsel,
defendants.
just to piggyback on that, but wasn't there something in the record here that there was an explanation for the discount, that you had to bring up 2 attorneys up to speed because the counsel that was in charge had to do something else, and that they didn't,
Yes.
you folks didn't find it, equitable that you'd be charging somebody for getting
Yes,
people
in
up
the
to
underlying litigation, there was a foreclosure proceeding.
Right.
And the court had set down an emergency expedited hearing. And unfortunately, it was on a date when lead counsel, Mark Walfish, was going to be out of the country. So we did bring in 2 other senior litigators of the firm, David Katsky, who was a named partner of the firm, and Adrian.
That was explained to the client. That was explained to the client. This wasn't just sort of internal type of, we're not going to tell her why we're giving her a discount.
No, of course. They were certainly told. There were certainly meetings with David Caskey and Adrian Koch to get them up to speed. And what we said in actually the August 12 email when we finally delivered the July invoices, Mr. Walfish wrote in his email, a contemporaneous email that says, our firm has given you a courtesy discount of $25,000, which is the approximate cost of the time in getting David and Adrian up to speed, which I did not feel was appropriate for you to pay. So there's a contemporaneous email to this effect. Again, Your Honor, there was no written objection, no response to that email, and where there's no written objections, where the June invoices were partially paid, and the claimed oral objections in the affirmation of Toby Moskowitz, which is part of the record. It's a 3-page affirmation where she says that she vehemently objected to the bills, but it's entirely conclusory because she doesn't say who she complained to, when these discussions were supposedly took place, or even the substance of these conversations. Ms. Moskowitz also said in her affirmation that she directed the firm not to perform certain services. Of course, she had our bills, detailed time records for over a year. By the time she submitted this affirmation to the lower court, she couldn't even explain what services she claims were not even authorized. So these are all conclusory claims. And we submit, Your Honor, that the lower court should have found that the defendants, and this is in the Court of Appeals decisions and Your Honor's decision, the First Department's decisions, that the defendants' self-serving, bald allegations of all protests are insufficient to raise a triable issue of fact.
Thank you very much.
Thank you.
May it please the court. Good afternoon, Your Honors. My name is David Miller. I'm with the Law Office of David E. Miller, LLC. I represent all of the defendants in this action and all the respondents in the appeal. Why are we here? We're here because the Cassidy Corns firm doesn't want to take the steps it needs to take to determine whether or not it's entitled to the judgment it wants. They move for summary judgment prior to there being any discovery being sought or provided by any party.
But Counselor, let's first start with the law as expressed by your adversary. It's correct. I mean, that's what we have said and the Court of Appeals has said. So why would discovery be necessary? Because this is all information that your client would have. I objected on X, Y, and Z date. Let's assume even there were oral objections. I spoke specifically to such and such person. This was my objection, et cetera, et cetera. Why is discovery necessary?
Discovery is necessary to flesh out who is telling the truth. You have a he said, she said in this case.
But respect.
Counsel,
Go ahead.
Don't we have a legion of cases from the First Department which say that there have to be specific evidence of objections, just bald conclusory allegations, I objected, is not enough. And in this case, as to the June invoices, There were partial payments, which we also hold obviates any account stated.
Well, 2 points in that, Your Honor. First of all, I'd like to direct the court's attention to Morrison, Cohen, Singer, and Weinstein LLC v. Waters. There, this court held that the receipt and retention of an invoice without objection with a reasonable period of time or partial payment may give rise to an account stated claim. May. May is not shall. So this court's own precedent
What
says
evidence is there of concrete objections by the defendants to the invoices that were rendered?
the only concrete evidence, Your Honor, in the record is Ms. Moskowitz's own affidavit. The only evidence in the record for plaintiff's position is an affidavit, an affirmation by their attorney.
Well, the plaintiff has the invoices, so it's your burden to come forward with evidence of some objection. So we have her statement that she objected. What specificity does she give in terms of the objections that she provided?
She says that she vehemently objected to the bills, that she felt she was overbilled, that she told
Does she say when she made the objection? Does she say who she made the objection to?
the affidavit, is not clear on those facts.
Well, isn't that exactly what our case law requires, that there has to be some specificity when you say that you made oral objections?
No, Your Honor, because there's a difference between determining that there is a question of fact sufficient to deny a motion for summary judgment, which is what Judge Crane did, and we submit did properly, and determining as a matter of law what was done or submitted is insufficient to meet the burden. I want to also turn just briefly to the partial payments question, because I think this is really critical. The record is clear, and we don't contest that the respondent sent some money to the plaintiffs. The plaintiff decided to apply it to the June invoices. The plaintiff then says, well, that's a partial payment. That was out of the respondent's control. The respondents did not give any instruction. There's no record anywhere of what that money was for. So the argument that those partial payments as to the June invoices we submit isn't really evidence of anything at all. Secondly, even if it were true that those partial payments were meant for the June invoices, or even if we accept that they were meant as partial payments sort of in general.
Had you received the July invoices at the time you made those payments?
I believe the June payments have been received, but that's the second point, Your Honor, is that there's no way that those partial payments in June can be held to constitute an acquiescence to the August invoices, because the August invoices hadn't been mailed out yet.
I don't think that they are making that claim. I think that they're saying that that's a partial payment for the June invoices, and that then subsequently on August 12th, you got the bills for the July work, and those bills you never objected to.
Well, I actually don't read their papers that way, Your Honor. I read them as saying that they think they've made both prongs of the test set forth in the law as to all the invoices, and that's simply not true.
Anything else?
No, Your Honor, I'm sorry, Your Honor. I was just looking at my notes for a moment. If the court has no further questions.
Thank you very much.
Thank you.
Just two very quick points, Your Honors. With respect to discovery, I just want to kind of bring the court up to date as to where things kind of stand with discovery. A note of issue has been issued pursuant to a prior order, and there was a motion to vacate that note of issue, and the court refused to do so because all discovery has been now completed. Defendants chose not to seek discovery, and in any event, the court said that the defendants have failed to show any documents or anything in our possession that they would need for discovery. So that was one of the reasons why their motion to vacate the note of issue was denied.
Sir, what about your friend's point? Oh, go ahead. Sir, what about your friend's point that the affidavit of Ms. Moskowitz was sufficient to raise a triable issue of fact as to whether she duly objected to one or more of the invoices?
The affirmation that was submitted, there was an affidavit by counsel who has no personal knowledge, and then there was the affirmation of Toby Moskowitz, who was the client. Ms. Moskowitz speaks in totally conclusory terms. She doesn't give any specifics, which is required under the controlling law. And just to switch back for discovery for 1 second, there are cases that we have cited, First Department cases, Lapidus versus Elizabeth, for example, at 92 AD 3rd 405, which specifically says that no discovery was required in connection with this type of accounts data claim. If the court has no other further questions,
Okay, thank you very much.
thank you, Your Honor.
The session is now completed.
They saved the best for last, huh? I could see you looking at your watch and